Thune.
Thank you, Mr. Chairman. And, Mr. Chairman, I think we ought to, have these nominees think that their confirmation is still in doubt until they answer these questions, make sure we get the right answers. I want to direct this to Mr. Thornton and Mr. Nega, and I appreciate the fact that it may not be appropriate to comment on specific cases before the tax court, but I want to raise a recent tax court decision that caught my attention, and it was Morehouse versus IRS. The court recently ruled that Conservation Reserve Program payments are subject to self-employment taxes, even where the individual receiving the payments is not actively farming the land. And in this particular case, the individual inherited the land in my state of South Dakota, but he lived in Minnesota and was not actively engaged in farming. Yet the tax court broke with prior decisions in finding that the taxpayer had to pay self-employment taxes on the CRP payments, whereas prior court decisions had found that a CRP participant needed to materially participate in the farming operation in order to be liable for any self-employment taxes. This decision is concerning for a lot of reasons, because the heavier CRP payments are taxed, the less likely it is that owners of environmentally sensitive farmland will want to participate in this important conservation program, which will increase taxpayer liabilities under crop insurance and disaster programs. In other words, moving it into crop production as opposed to keeping it in CRP. And so I guess I just would be curious if either of you have any views on this issue of whether these forms of payments, conservation reserve or CRP payment, should be subject to self-employment tax in instances where the owner of the farmland is not actively, or is not considered, I should say, actively engaged in farming.
Senator Thune, I would address the question more generally, I suppose, by explaining the process of the court. All the court's opinions are reviewed by the entire court. We have 19 active judges when we're fully staffed, and we all review all the decisions. In making that decision, we try to adhere as best we can to other judicial precedents. I believe in that particular case there were other appeals court cases that the court looked to. The tax court sits in 74 cities throughout the country, and 12 cases are appealed to 12 different circuits. So we're bound to apply the law of that circuit in each of wherever the case might arise. So it is those types of considerations that play into the court's decision, trying to make sure we're in the mainstream of the legal system, trying consistent with the jurisprudence of the appeal in which the case originates. But I assure you that every case is decided only after very careful consideration by the entire court of the particular facts of the case, the law of the case, and as the court believes Congress intended the law to apply. As to the specifics of the outcome of this case, I'm not at a very good position to comment on that, but that is the general process by which we try to decide all our cases.
Okay. Anything to add, Mr. Nega?
I have to admit that I'm not familiar with the facts of the case, so I'm really not in a position to respond at this point.
Okay. Well, and I understand it's like I said, it's not it's a pending case, but I just think in terms of tax principle, tax policy, the payroll tax, self-employment tax is a federal tax, and in the past has never been applied unless there was material participation in a farming operation. And this is a pretty important precedent for a lot of reasons, like I said, one of which is that we're doing everything we can to keep some of these environmentally sensitive lands in the CRP program. This is yet another disincentive toward that. If those who own farmland perhaps aren't materially participating in its operation but are benefiting from the CRP payments are assessed self-employment taxes, that's obviously a tax consequence that's going to affect the decision that they make, the economic decision about whether or not to keep it in the program. So just put it on your radar screen if nothing else. Mr. Reif, the ITC has many important functions. The Commission has recently received a good deal of attention around these 337 cases, which you mentioned, which are cases where one party is asking the Commission to issue an order stopping the importation of another company's product. As you know, these cases often involve high-tech companies who find themselves at odds over patent disputes. Given your expertise in this area, I'd be curious to know if you believe the ITC process for considering these cases is currently working, or if these cases wouldn't be better suited to district court where monetary damages could be awarded as opposed to these exclusion orders.
Thank you, Senator. I think
you're absolutely right that these are important issues and that they do have impact. The Commission has a tradition of wrestling with these issues pretty well, and like many things in life, it can be improved, and the Commission has taken steps to find ways to help resolve disputes quickly that really shouldn't be in the dispute process. So faster ways to make earlier decisions in the matter when it just seems like there really is no dispute, no genuine dispute. And that's a tool the district courts have. They have Rule 12, they have Rule 56. The Commission has developed its versions of those approaches, and so far, those seem to be meeting with good results. Other techniques can be tried as well, and I would enjoy working with my colleagues to help do that if confirmed. Ultimately, though, it's up to this body and the Congress and the President to decide whether the Commission has this role.
Yeah. Do you think, though, that these cases are better suited to district courts where you can have actual monetary damages awarded as opposed to the outcomes, the reliefs that are allowed for under your jurisdiction?
Let me just break in here. You can continue as long as you want, Senator. I must leave right now. It's a vote occurring right now, too, but it's up to you. You can speak as long as you want, but I just...
You want me just to gavel us out? Or are you coming back?
Yes. I'm not coming back. I can't.
So I should pronounce them confirmed? I'm sure they might appreciate that.
You can tell them that we're going to schedule a vote on their confirmation as quickly as we possibly can.
All right. Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
Yeah. Thank you, Mr. Chairman.
Senator Thune. Senator Thune, please.
Right. Well, yeah, I was just going to ask you, again, to get your thoughts about whether or not these are better suited for district court.
Yeah, so I think that there's a lot of interesting work that's been done to analyze how district court proceedings on their own terms work, how commission proceedings at the ITC work, and there seems to be a pretty good consensus that there are a lot of pluses and minuses to both venues and to both types of remedies. So the district courts, as you point out, have the remedies available, damages and injunctions. The ITC has the remedy available, the exclusion order. Those really are different things, and my understanding, having really enjoyed working on these issues for a very long time in each of these settings, is that there are pluses and minuses to each of them, which then means trade-offs have to be made. Those are ultimately policy questions.
Okay. You guys have anything? I guess that's a wrap. Thank you all very much, and this hearing is adjourned. Thanks.
Thank you.
Thank you.